All right, we're going to talk about, is seller financing legal? Yeah, it's absolutely legal. It's legal in every state of the United States, and it's legal in Canada, and it's been done for hundreds and hundreds of years, and there's thousands of deals that are done every single year. Now, here's the misconception. For the last 10, 15 years, it's been very easy for anybody to go out and to get a bank loan. I mean, you literally only had to have a heartbeat and a job, and you could go get a bank loan. There were situations where you didn't even have to have a job and you could get a bank loan because it was stated income. There was no proof required. So for most people, there was no need to look at alternative ways to finance. But when banks' lending guidelines are tight, seller financing definitely is on the rise. You've probably begun to see articles in the news, you see articles in all the classifieds, where people are beginning to offer seller financing. Now, so to simply answer the question, is it legal? It's 100% legal. But the misconception comes from the fact that, one, it's not been needed traditionally for the general public, and two, there's certain provisions, there's certain acts that are in promissory notes and deeds of trust that are created by the bank that makes people scared to consider seller financing. Now, here's why. When you look at the way a traditional loan is created, it's created so that the amortization schedule, all the interest is paid up front. Really, anywhere from 60 to 80% of your interest is paid in the first 7 to 10 years of the mortgage. But the interesting thing is most Americans move, on average, every 3 to 5 years. Well, it was in the 1980s. The banks knew this. They knew what the numbers said. They knew that Americans move every 3 to 5 years. And additionally, they knew that the amortization schedules were heavy on the front end. So if the banks could get people, they could get families and individuals, every time they moved to get a new mortgage, they'd always be paying interest their whole life. Additionally, in the 80s, the interest rates were in the teens. They were in the high teens even. And in 1982, the banks lobbied Congress to change the way in which the promissory notes were written. And one of those big changes happened through the Garn-St. Germain Act, happened in 1982, and the due on sale clause was introduced into the promissory notes. And the due on sale clause simply states, if a seller of a property, the owner of a property, chooses to transfer rights, ownership of that property, we, the bank, we reserve the right to call the note due. Well, really, when you look at that, banks are in the business to protect themselves. So it's no wonder that they want to put everything in a promissory note that says, hey, look, if you don't perform exactly how we say you need to act, then we reserve the right to take this asset back. Because the banks lend hundreds of thousands of dollars and receive interest payments, they want to protect themselves. Well, the interesting thing is, I'm not a CPA, I'm not an attorney, but I've read a number of promissory notes and deeds of trust. And in these promissory notes, you'll find 99% of them have the due on sale clause. But they also have clauses in there that talk about hazardous materials, such as gas. If it's located on your property, the banks reserve the right to call the note due. If you move soil off your property or change the geological structure of your property, the banks reserve the right to call the note due. Additionally, even some are written that if you rent your property, they reserve the right to call the note due. But the one that most people hear about and focus on is the due on sale clause as it relates to seller financing. We'd have to look at a specific note at a specific property, and we'd really want to seek legal counsel as it relates to that to figure out if it's right for the seller. But in most cases, it's simply a provision. It's simply an act, part of the promissory note that you're choosing to break.